have said that you can't take an abstract idea and then say use a computer to implement it. But we haven't said that you can't take an abstract idea and then say here is how you use a computer to implement it.
Exactly.
Which is basically what you're doing.
That's the argument we're making.
And that's
the line we're asking the Court to draw here.
Well, how are you saying the how? Because I thought that your computers, that your patents really did just say, do this on a computer, as opposed to saying anything substantive about how to do it on a computer.
I would urge the Court to look at Joint Appendix 159, 285, 286, where it goes through the flow charts. This is just a specific example of the method by which you stop a transaction. And it goes through a very series of detailed steps and what the computer has to do in order to do that. It doesn't actually obviously put in the code, but that's what the PTO says don't do. Don't put in the code because nobody understands code. So, but put in the functions, and we know that someone skilled in the art will be able to put in the code. And if they can't do that, then it's not enabled, and that's a 112 problem. To go back just
before we get back to these matters, you said to Justice Scalia, if a patent sufficiently describes how a computer will implement an idea, then it's patentable. So how sufficiently does one have to describe it? What do we want a judge to do at this threshold level in terms of trying to figure out whether the description is sufficient to get you past it?
If I can answer in two steps, Justice Kagan. First, in the negative. What the applicant or patentee must not do is simply describe the desired result. That would take us back to State Street. That would simply say, I claim a magic box that buys high and sells low, or vice versa, I suppose. I may claim a magic box for investing. That's what these patents do. And then to put it in the affirmative, and in the language of Mayo, the claim has to recite something significantly more than the abstract idea itself. That will be a contextual analysis based on the claims and specifications and file history, and we know that some devices, some methods, some programming will pass that. It is not going to be a bright-line rule, and that's one of the tug-of-war issues that this Court and the Federal Circuit have been having in these cases. The Federal Circuit wants bright-line rules. All computers are in or all computers are out. This Court has been more contextual. This Court has been more nuanced. This Court has looked at things in a more robust way.
You're not suggesting that specific code is necessary?
No, Your Honor. I think the actual description of the programming is a 112 problem. I agree with that, a 112 issue. That is the realm of the written description requirement. What is a 101 problem is it is on the applicant to do more than simply describe the result. Simply say a magic box that does intermediate settlement. And we can...
reach software patents at all in this case?
Well,
what's the necessity for us to announce a general rule with respect to software? There is no software being patented in this case.
Well,
systems.
Well, I think there's a process being and one can think of software patents as process patents, and I think that's why my friends on the other side are saying the sky is falling, because they are interpreting what we're saying about when a computer's involvement makes something eligible under 101 is calling those into question. And
do you think we have to reach the patentability of software to answer this case?
Well, I think you can. I think the answer to that question is no, not necessarily. You can decide it by saying that Bilski answers the question of whether this is an abstract idea, because this form of hedging is really no different than the form of hedging as a conceptual matter at issue in Bilski. And then Mayo answers the question of whether the use of a computer in this case adds enough to the abstract idea beyond conventional steps, because here all we have, after all, is just conventional use of computing technology, no computer innovation, such that you don't qualify under 101. You could take that approach.